似啦，夠人啦應該。我哋先請政府當局同埋私隱專員公署代表入嚟啦。咁就我哋手上都應該有晒之前嘅各份嘅文件啦。咁私隱專員大家都記得7月其實都好耐啦嚇，7月29號嗰陣時呢就委員就對當局就私隱專員關注嗰啲佢俾6項項目啦，我哋就講咗3樣嘅。咁就我諗今日呢，我哋就希望講埋另外嗰3樣嘅關注嘅內容。咁大家如果記得嘅呢，我哋講咗嗰3個應該就係登記為醫護者、登記醫護提供者、登記。
With regard to healthcare providers and also the data subject will not be allowed to give written consent for making requests for access and so on. So there are several outstanding items. It's about safe deposit box offences and also restricted liability offences and so on. So we will have to discuss those today. After you've all been seated, I'll be inviting Mr. Sidney Chan, head of the e-health record office, to walk us through the details. Before I invite Mr. Alan Chiang to make a response, we'll be asking questions then. I think we've already discussed those, so we can be brief so that more time can be given to members to ask questions. Thank you. Last time we discussed the 6 comments made by the Privacy Commissioner, and now we'll be talking about item 4 and 5. And 4 is about the safe deposit box issue. And over the past meetings, different members, and also during the public consultation exercise, we heard views from different deputations on this. With regard to this issue, there are pros and cons, and there are also views in support and against this. So it's not a question of right or wrong, but then some might attach more importance to patient's choice and whether or not he or she can decide if she'd like to allow access to certain persons, and also whether or not security can be stepped up in certain areas and so on. On the other hand, the other camp is of the view that if you hide certain information, would that render the patient in danger, and would that give rise to other problems and so on. So all these have been discussed on previous occasions. So maybe we can also invite the Privacy Commissioner to share with us his views. All right. On item 4, on safety deposit or safe deposit box, can the Privacy Commissioner share with us your views? Well, at the last meeting and also in some discussion papers, we have already discussed some of the issues, and one of the points made by the Bureau is about some proposed CSAs, and they've already offered to make some amendments, and only in certain specified circumstances will the HCP be allowed to have access to the HCR's data, and there are also certain controls, but then it's still not good enough, because we are still not satisfied that he would only have access to such data on a need-to-know basis. And today we are discussing the issue of safe deposit box, and as the Bureau said, there are pros and cons on this issue. But then I've also noticed that generally speaking, the HCP would like to have a complete picture of the medical record of the HCR in order to ensure that treatment can be provided in an appropriate manner. But then, from our perspective, there is no way that the HCP will be able to have 100% grasp of the medical history of the HCR in any case. And in any event, such data or such records would only be of reference value, and of course, the more the better. But then, in reality, as the whole system is provided on a voluntary basis, and therefore the patient would also determine if certain information would be withheld from the system, and as a result, the HCP in the circumstance would only be able to provide the service to the best of its ability in the circumstances. That's why if we say that only if a full record of the patient is provided to the HCP, will the HCP be able to provide comprehensive service or suitable service to the patient? I think that would be next to impossible, and therefore at the end of the day, I think we should leave the choice to the patient, and the patient should have the ultimate say as to what data should be incorporated in the system, and in certain circumstances, if certain record of the patient has to be used or accessed by the HCP, then the HCP will have to seek the consent of the patient, and then the ultimate say would rest with the patient. And of course, the pros and cons would be that, by giving the consent, the HCP will have will be better informed before making certain diagnosis and treatment. But then the good thing about this is that the HCP will not have enhanced liability as a result of this, and we believe that so long as the patient can make the decision on an informed basis, that would be okay. So all in all, after looking at the papers for those who are against this, I believe that for those who are opposed to this, and if you count the votes, well, apparently there are more who are in the opposition camp. But then if you look at the strings of the arguments, apparently not many people have been able to put forth very strong arguments against this arrangement. So my impression is that given the fact that we have already discussed this for a number of years, it's time for us to come to a decision now, and my inclination is that there should be express provisions in the bill that the system should allow for such access. But then in terms of the details, as the administration has said, we might have to sort out the details later. But then during the past few years, we have had a lot of discussions on this, and that is at the end of the day, for certain parts of the records, the patient should have the right to withhold such information. In other words, only with the patient's consent will the HCP be able to have access to such information before providing treatment to the patient. I think that's the right approach. As to how it's going to be implemented and so on, I think the details might have to be the subject for another round of consultation. Yes, I'd like to supplement, because these arguments have been put forth in earlier rounds of consultation, because under the EHR, well, originally we intended to include this in the second round of consultation before a decision is taken. That's according to the administration, and technically speaking, we may not be able to do that right away upon the enactment of this bill. That is, we may not be able to include this in the safe deposit box, so to speak, upon the enactment of this bill, because some of the specifications have yet to be worked out. So, Commissioner, can I confirm with you this? That is, at this stage, if we were to make a decision, that is, if we believe that this is necessary, this is good, and even if we are not able to achieve that at this stage, then in the next round, we can conduct another round of consultation before implementing that. Is that what you meant? Yes, indeed. Given the fact that we have already discussed that for years, I think we should leave it to the second stage. My own inclination is that if you look at the strength of the opposition, in fact, they are not very strong, and it's not too difficult to come to a decision. That is with regard to such facilities, if we provide that expressly in the provisions, and then in terms of the actual implementation, we can leave it to the next stage so that further details can be worked out after consultation. I suggest that we should also come up with a timetable, or else it would all be reduced to something in writing without actually having a commencement date. So I think we should have a timetable for implementing the details, and then the details can be the subject of consultation in the next round. All right, so we will open the floor first, and then we'll ask the officials to respond later. Dr. Kwok Kak-ki, thank you, Commissioner, for coming again to brief us on the idea or the concept. I agree with the Commissioner's description of the concept of a safe deposit box. In fact, that has to do with item 7 on the paper. That is about the need to know. Because for any HCP treating a patient, he needs to know the information about the patient at different levels. For example, when a doctor sees a patient, the most important thing that he needs to know is whether or not the patient has allergy to certain medication or certain substances. And also there are other records, for example, his blood type and so on. And if we are to ensure that it's going to be a good system, then number one, there is no way that we can take away the idea of something that the HCP would need to know. And if you do not classify them into different levels, then it's not going to work. And secondly, it's not going to help the HCP in providing care to the patient. And when an HCP has access to certain system, for example, if it is about the patient's previous medication records and so on, it's not going to help the HCP at all by providing him with too much information. For example, in the records, we have already got this practice. That is, the patient's information will be classified into different tiers. For example, for important past medical or medical history, and also the medication that he's taking, and also whether or not he's allergic to certain medication and so on. This is already being done.
So when you talk about huge difficulty, I'm not sure where that lies. And I agree with the Commissioner that whether we are going ahead or not, it is about how determined you are. If we don't have any precedents around the world and therefore Hong Kong shouldn't do it. Actually, in many places there is no such health record sharing. Should we wait until everyone else has done it? Of course not. And what about the octopus card system or concept? It was run as a pilot scheme. So we should not say that there are no precedents elsewhere and we should wait. It is just an excuse. The administration have said in the past that there are many stages. This is only just the first stage. Perhaps we should leave the concept of the safe deposit box to the next stage. As the Commissioner has already said, this is about whether you respect the service recipients or the patient's rights. More than once we have received comments or complaints from patients. Very sensitive information. They do not want to have it disclosed to other HCPs. Perhaps it is someone who has recovered from mental illness. He has a headache, but he goes to the emergency room. The doctors will say, "Oh, you must have an episode of mental illness." So they feel very aggrieved, and they feel that such information is simply irrelevant to their current case. So when there is a thorough checkup, the HCP can identify relevant information, the state of mind, so on and so forth. If the patient does not talk about medical record, the doctor can place the blame elsewhere when he fails to come up with a correct diagnosis. In other words, the diagnosis is not totally based on the medical records. It is more relevant in terms of directing the HCP to the right diagnosis and right treatment. For example, many patients may not support or agree to record sharing. Is that justification or an excuse for HCP not to find the right diagnosis? Of course not. So if we combine different things, some patients will not use the record. Some would use the record, but they retain that safe deposit box. Many patients without the safe deposit box feature will not agree to this sharing system, and at the end the system will become victimized. For privacy's sake or for sensitive medical records, people don't want to share information. Without this safe deposit box feature, you are chasing them away, and at the end there will be less people using the system or having confidence in the system. So it does not help the HCPs, does not help the government, does not help us in promoting the system. So I agree that at the opportune time, the government needs to be committed to a direction. If you are to do it in the second stage, you have to make sure this is feasible. You should not come up with reasons or excuses saying that this is not possible. You can come up with 100 excuses very easily, saying that you can't do it. It is about how determined you are so that we can launch it smoothly. If you want this to be a success, you have to address people's concerns. So the patients are willing to provide you with the medical records. Otherwise, you cannot attract people to join the system. You are spending hundreds of millions of dollars, and at the end, people don't want to tell you anything. So I want to get a reply from the administration. All right. I haven't set any time limits because there aren't too many members here, but I hope that you won't talk for too long. So, Mr. Chen, do you have any reply? You want to collect more views? All right. Madam Kwok Hui Fan. Thank you, Chairman, and thank you, Commissioner, for coming here to discuss this topic with us again. In the past, I have submitted some written information, and I've expressed my stance very clearly in the past. I support and I agree with the Commissioner's proposal that we should confirm this safe deposit box feature, and it should be written into the bill, and there should be a timetable for implementing this feature. All along, if we refer to the administration's reply, they mainly talk about a number of issues. First, what the public thinks. I agree with Dr. K.K. Kwok and also the Commissioner that the public's views are very clear. If we refer to the report on public consultation, objection is quite limited. 18 people suggested that there should be safe deposit box feature and only 5 objections. And the chairman of the health panel also requested that the feature should be incorporated into the system. So the commissioner, patient groups have asked time and again for the setting up of the safe deposit box feature. So I don't see strong objection from the public. But of course, I have been told by some doctors that without comprehensive medical records, coming up with a right diagnosis or protecting patients' health may be undermined. I've actually talked to many doctors, and some do not agree with this. Even when patients bring forth their medical records, they feel that it may not be most updated. They will check the person, they will examine that patient and do some tests. So no one can guarantee that the most comprehensive medical record is always provided to the doctor by the patient. Many patients basically don't provide such records to the doctors. So it is not realistic to think that we can provide a right diagnosis based on such comprehensive records. I agree with Dr. Kwok. We cannot wait until everyone else has done it successfully around the world. We are the pioneer. After the last meeting, I have provided information in other countries. For example, Denmark is very actively promoting this feature of the safe deposit box. So I don't understand why the government insists that we cannot move ahead without successful precedents elsewhere. Dr. Chang talked about technical difficulties. The chairman also talked about that. But I'm in the IT business, and I have talked to many of my colleagues, and people don't think it is a huge difficulty. So I don't agree that it is a fact. If you believe that there are technical difficulties, you should set up a technical committee or group involving IT experts to resolve the issues. Okay, Mr. Chang, would you like to respond? Or Ms. Emily Lau also raised her hand. Maybe you can put forth your questions first. Thank you, Chairman. I will be very brief. In principle, I agree. And we support the Commissioner. We appreciate his attendance so many times to help us work on this bill. I always talk to the administration, why don't you listen to the Commissioner? I know that you have had meetings, but I don't know what are the results. Things seem very different after such meetings. Anyway, we want to find a consensus and come up with something that is most in line with public interest in Hong Kong. Perhaps we'll hear the reservations from the Bureau side, and we can see how we can resolve the problems. Even if no one else is doing it around the world, we can still move ahead. But if it is a huge exercise and there are no precedents, the government always end up being criticized. So I understand that perhaps you're trying to be careful. If there is consensus in the community believing that we are in the right direction and our officers have done so much, you need to tell us honestly what the problems you are facing and see if we can resolve them and whether you can really respond to the demands. If they can be resolved with the backing of LegCo, you should go ahead. And we can be collectively held responsible if anything goes wrong at the end. So I just want to hear the truth. Are these things feasible? Or if they are not feasible, how can we better deal with them? Mr. Chen, please. Thank you, Chairman, and thank you, members. Perhaps I can respond to your views and share with you our considerations. First of all, I would like to clarify something. I must reiterate that the government is not saying that we won't incorporate the safety deposit box feature. We are just reporting to you in recent years, in public consultation, and also when we came to LegCo, we have heard some views. We have heard divided views. There are people who support and there are some who object. There are associations including doctors and dentists and some elderly groups. I cannot ignore the voices from any major stakeholders. So we have really heard very divided views in the past. And because of that, and together with technical difficulties, we wanted to move ahead with a study to see if there are relevant experiences around the world. That is the first thing I would like to clarify. We do not have any established position. The second issue is about timing. Back in 2009, we started this 10-year, two-staged HR system. And we just completed the first 5-year plan. And we have only covered the basics to allow basic operation of the system. We will also draft the legislative framework. It was the thinking at the time, and we specified that in the stage 2 we will add other functions such as X-ray slides and also patient's platform, allowing patients to read the record, or safe deposit box feature to allow patients to decide who they want to disclose information to. For more complicated functions, we wanted to incorporate them in stage 2. So while we are in stage 1, we cannot turn back the clock and say that next month we need to come up with this safe deposit box feature. The only thing we can do is that in the second 5-year, we can move ahead with these things. That is why we don't have it ready today. I've heard members' views, and I hope that you do not misunderstand that we don't want to do it, or we are just dragging things along, pretending to have a study, and then we will say, oh, whether or not we should do it, and there are so many limitations, and therefore at the end we decide not to do it. I don't want you to have that misconception. So I would like to spell out our direction in response to all 3 members. The direction of the study focuses on what type of design or what options would allow patients to have better control over what information they would like to disclose to whom. So this is whether or not exercise. We are adopting a very different approach instead. We expect there will be a report submitted to us, and I trust that this direction should satisfy your requests or remove some ambiguity.
In terms of the timing, we will be delaying it until 2019, towards the end of the second stage, before we come up with any suggestion. No, please rest assured, we don't have to wait till the end of the second stage before we introduce some new functions. That's not our thoughts all along. If we are able to do it in the 7th or 8th year, then we'll be more than happy to do it. For example, I talk about the X-ray images or patient platform, and also new designs to enable the patient to have a bigger say in deciding what information should be provided to the HCP. And of course, we will have to wait till we have the result of the second stage consultation. We will also have to consult the patients groups and also the HCP groups. And in the end, if we all accept that that's the direction that we'd like to take, then we'll be more than happy to do it. So that's the fastest timetable that we can come up with. That's the 6th or 7th year. So we'd like to adopt a more positive approach by giving this undertaking, and we'll be prepared to do it at the soonest possible date. We hope that that will be acceptable to members. All right, we have some members just walking in. We have Kwok Kaki and Elizabeth Kwok. Both have raised their hands, and the administration's response might not be exactly what members have been asking for, because they'd like to have a timetable right away. But then the administration is suggesting that that should be left to the second stage consultation. Yes, KK Kwok and then Elizabeth Kwok. Well, it's a brief point, because I've heard Mr. Chen's response. So you'll be setting out the direction very clearly, but then there is one thing that I'd like you to clarify. That is, you talk about the direction to take is about how to implement it, and I welcome that. And second, you said that there would be a further round of consultation, including a consultation with the HSP. We understand that. We also believe that stepwise, that's the way forward. But then does it mean that if there are some HCPs who are against it, or, well, I don't know what the response of the HSP is going to be like. And indeed, this Bills Committee can also work on it, because most members of the Bills Committee overlap with that of the HSP anyway. So if there is no differential view between this committee and the panel, then do we have to wait till all the healthcare provider groups have agreed, or in doing the consultation, would you be setting out the common concerns for consultation? For example, the nursing council or the medical association have got some concerns, but then their views are pretty positive. That is, even if there is a safe deposit box, whoever needs to have access to the information agree that this feature should not affect the treatment to the patient. If that is the case, then the direction that the administration should adopt is, well, for people with different views or concerns, well, in your future study, they should be positively incorporated in the system, so that in the end, the safe deposit box feature should be one that, well, whether it's the database or the HCP having access to the data, they would not feel blocked, or they would not feel hampered. So we do not have to have all the stakeholders' consent before we can introduce this feature. All right, Dr. Kwok. Yes. I hope that the administration can clarify this again. All right. Is it that the administration does not have preconceived ideas and it would not be delaying this anymore? But what we'd like to know is that, well, we are not asking for a no preconceived idea stance from the administration. Instead, we'd like you to have a very clear stance on this, because we have been looking into this for years, and I think it's time for us to come to a decision. And I don't think there would be any suggestion that would not meet with any opposition at all. So does it mean that you will have to go out for another round of consultation, and you will only wait till there is no opposition before you're prepared to introduce it? If that is the case, then I'll be very concerned. And also for the safe deposit box, we'd like you to include that in the provisions, because that's suggested by the Commissioner. And I think that's the safest way to guarantee that you're going to do it. So the Commissioner has agreed that this is a good approach, and I'd like the administration to respond to that. Yes, Commissioner, can you also suggest to us as to how these provisions could be drafted? And administration first. The reason why we think that we should conduct a study first, because during the first 5-year plan, we did not intend to include this safe deposit box feature in the first stage. We only intended to introduce a system that would basically be operable. So we will have to look at the objective in the second stage and what it proposes to do, because this is just a vague concept, and during our consultation exercise, we would like you to understand what this means. So it's like a safe deposit box, and if you do not want certain information to be accessed by other people, then you can always keep it in the safe deposit box, and only with your consent will other people have access to that, so that the patient will be able to determine if he would like to allow access to some of his information to other people. So it's not a universally agreed feature. For example, if you go to the UK or Canada or even Australia, if you just say that it's an e-health safe deposit box, then people may not know exactly what you're talking about, because in different countries, well, for the information that can be withheld or protected, that would be different, because we have also given some examples of 4 or 5 countries. For example, in France, they actually mask the information, and you can also decide not to tell people that you've actually hidden something. But then in other countries, you will have to tell people that, all right, I've covered up something, but then I will have to inform people that I've hidden something. And in the UK, you can hide something, but then there are things that are too sensitive. You will not be allowed to cover it. And in Australia, initially, they allowed a patient to withhold a certain information, but then now 4 types of information would not be allowed to be withheld. So in different countries, they adopt different approaches. We are not suggesting that we should follow the example of any one of those, but then we need to look into our own circumstances before we determine what we're going to do. And if we do not have any design in mind, then how can we put these abstract things in the provisions? Because if we just say that there's going to be a safe deposit box, then nobody will understand exactly what it means. And also, secondly, we have always stressed that this is a technology neutral thing. So putting aside the safe deposit box feature, well, in designing the system with regard to the system structure, we have deliberately leave it blank, because we'd like to make sure that the shareable information under the system can increase in future. So we have not set out specifically as to the functions of the system and what it can do and so on. Because we don't think that by including the technical details, for example, we have to rely on the central server or the internet, we don't think that's the right way to do it. But then by not including these precisely because we are technology neutral, that's why in the 6th, 7th, 8th, and 9th year, if we want to introduce new functions, we do not have to amend the law before we can do it. So that's the main consideration in designing the bill, and we have purposely not included certain details in the bill. That's because we would like to make it flexible, and that's the reason why we have not included the provision on safe deposit box, because we intend to do it in the 6th, 7th, 8th, or 9th year. Sorry, Chairman, I think Mr. Chen has not answered the question about having to obtain the consent of some of the stakeholders who had opposed to it in earlier rounds of consultation before you would be prepared to introduce it. Well, we did discuss the issue of safe deposit box, and many people have expressed views on this. But then, as I said, it's a very vague concept. To some deputations or groups, they might have a different idea about this, and they might think that it's like the one in Australia, and then the patient can decide which information should be withheld. But then, if it's only confined to specifically or particularly sensitive information, or if it's only blocked on 1 or 2 occasions, then the stakeholder might be prepared to accept it. So as we have not got the specific features in the consultation exercise, there is no way that we can tell if a particular group is for or against it. The most important thing is to ensure that both the HCP and HCR would find it workable. But then the most important thing is, in the end, there are bound to be people who are against it. And you're not intending to get 100% buy-in before you would decide if you're going to do it or not. In the end, you will have to come to a decision anyway. Is that right? Well, in conducting the study, as we have said, under the EHR scheme, we have a steering committee, and it comprises 3 patients groups and also different healthcare providers groups, and therefore, during the first round of consultation, our initial conclusion is that we should be discussing that at the expert domain groups and also the steering committee, and only if we think that is workable, then we will put it out for consultation, because there is no way that we'll be able to get 100% buy-in. But then the most important thing is most of the stakeholders would agree that it's feasible without affecting their important principles. Chairman, I agree that the steering committee will be playing a very important role in the process, but then I also hope that you would understand that this bills committee also represents many people's views. And if after the discussion in this council, and if you go back to the SC, and if the SC doesn't agree, then you're not going to do it at all. And if that's the stance that you have taken, then sorry, I'm afraid we cannot agree, because it's a waste of time for us. And if you respect the discussion in this bills committee and also the direction that we have taken, including the recommendation of the privacy commissioner, then I believe that before you come up with a recommendation, whether it's about the different approaches. You also cited 4 countries. In fact, there might be more, because in a few years' time, there might be more countries evolving into different systems. And in drawing conclusion from such experience, the administration should come up with a clear direction, that is respecting patients' privacy is the idea behind this safe deposit box feature. We can fully understand that you cannot possibly incorporate everything under the definition, but then if this is the consensus of this Bills Committee, the administration should respect it. I don't want to see a situation whereby after a lot of discussion and after the Privacy Commissioner has spent a lot of time on it, and then when it goes back to the steering committee, then it would just override all the discussion conclusions. Once you have put it in the bill, well, not all of us will be there by the time when you introduce an amendment bill, but then if you are prepared to include that in the bill, then we can see that there is a clear undertaking on your part in doing it. Mr. Chen or Privacy Commissioner, any suggestions? Well, I've already said that our undertaking is that, number one, we are not just doing a study to determine if we would like to go ahead with this. Well, the purpose of the study is to come up with a feasible package so that the patients will have more say as to what information can be disclosed and what cannot be disclosed. So that is to increase the patient's say in this. So that will be done, and in our previous written responses, we have already set that up very clearly. So definitely, you can always go after us for undelivered promise. So there is no question of us not honoring our promise in this respect. And in the process of discussing this, after the study has yielded findings, we will also be setting out the views and comments made by members and the Privacy Commissioner, so that the SC will fully take on board the views that have been expressed. That is, you'd like to have this feature as far as possible. But then at this stage, as we have not come up with the specific design of the feature, we are not in a position to comment any further. So are you trying to comment them? Commissioner, do you have anything to add after listening to members' comments and the administration's response? Thank you, Chairman. I think the safest approach is to do this.
Today we would like to reach a consensus so that we can move ahead with implementation. The best way forward is to write that into the bill, but of course how we should put it in the bill is difficult. That difficulty can be resolved. But if we cannot even write anything, the Bureau said that they have to do more consultation and they have to seek assistance in terms of the technical details. I think you need to spell out the concept before we can move forward to the next stage. You must have clear concept before possible follow-up can be done. It is not as simple as just writing down safe deposit box. No one would understand, but in my mind it is very clear. Without this feature or concept once you join the system, the information will be dealt with in a standardized manner. The safe deposit box feature allows some of the information to be dealt with in such a way that a question would be put to the patient to see whether they are willing to provide the information inside the safe deposit box. It is just one extra step. Perhaps what I'm saying is quite cumbersome, but I think you can somehow turn that into clauses in the bill and we can work on them further. if there are still divided views, but it is worth trying. But if we are looking at a very ambiguous feature, so ambiguous that it can't appear in the bill, then in the next stage, we don't have a very good starting point to work on implementation. 3 members have raised their hands. First round, Dr. Lankala. I remember the government said that there is no such safe deposit box feature in the UK. Or is it the other way around? I don't remember anymore. But the patient has the right to ask the HCP not to incorporate certain information into the data bank. So to a certain extent, it is performing the feature or the function of the safe deposit box, because the HCP shall not place the information in the data bank. In other words, people will not be able to see the information. If we are to write this feature into the bill, C1234, 12(6). It is about providing consent. Bracket 6 spells out the consent is for a number of things. The HCP can obtain information from the system, provide information to the system, and provide to a referral healthcare provider certain information. So we can work on the wordings here. We can write something extra. So when the patient provides the consent, the patient can make a request that certain information not be placed on the system. That is a feature of the safe deposit box. So when you digitize this function, you don't need that provision. Or you can spell out that when the patient provides a consent, he or she has the right to retain certain information, and the HCP is not to place such information in the system. At least you have to do that. So it is not an e-deposit box, but if the patient has seen a private doctor and there is information that is very sensitive, the patient can choose not to have such information incorporated into the system. So bracket 6a bracket Roman 1, just change it a little bit, because it says the consent is for the prescribed healthcare provider to provide to the system any shareable data. That is my concrete proposal. Mr. Chen, would you like to respond now on this point? There's another member, actually 2 more members. Do you want to hear from those 2? Miss Emily Lau for the second round. Thank you, Chairman. I really hope that if we are to incorporate this feature into the bill, we need to know what we are doing. In the past, we have done something similar. We thought we knew what was going on, but then at the end it was a huge mess. So the administration needs to be clear. This committee needs to be clear. If the commissioner or other doctors can provide some assistance, that would be best. All I hope that it is very clear. It could be very controversial. And Chairman, have we invited the strong objectors Yes, at the public hearing they have already expressed their views. I need to take out the comments. They have provided written comments. Yes, because we are actually getting it done. They may continue to object. So if we are to move forward, we need to consider their objections. But at the end, I hope that whatever we are writing down in the bill, we must know clearly what we are doing. Because the administration doesn't want to do it. Half of the 10-year plan is gone, and all of a sudden you ask them to do it, and they are not prepared. So we all want to move forward with this. How do we make it functionable? We need to know what we want before we can write it into the bill. I think that is very important. If the commissioner thinks that we can go ahead with it, just sit down with him and draft it together. I think that is important. I have not heard anyone saying that we can just casually put something down. Let's see what the commissioner thinks about this. Well, it is a rare opportunity because members here all support you, although you don't get the support from the medical association and other groups. If patients' groups are also in favor, then it is a rare opportunity that there is some sort of consensus already and we can all work on the difficulties together. Ms. Kopwifan, I also agree. The safest way is to work on how we can incorporate it into the bill and have the timetable for implementation. Otherwise, we are just going in circles. A lot of consultation has been done. We have heard views. If we still cannot reach any consensus, this bills committee is not very useful. So hopefully we can use time wisely and see how we can incorporate it into the bill. The most important principle is to protect the rights and decision-making power of patients. We cannot let go of that principle, and that is also relevant to public interest. After spending so much time and effort on the system, and at the end the patients decide not to use it because of privacy concerns, it will be such a pity and such a waste of the time and efforts from the government side. So as the commissioner has said, it is difficult but it's not possible, so why not go ahead with it? Thank you. So I think you have all expressed your views and your support the incorporation of this feature in the bill. Commissioner, would you like to respond? Because Mr. Leung mentioned on C1234 bracket 6, perhaps you can do something about this provision. Can you provide any response today? Or do you have to go back and look into the details first? I want to say two things. Just like any e-system or e-product, version 1, just like our mobile phones, is very basic version, and then version 2 you may have call forward, and then version 3 you can get online, and then 3D design for version 4. There is a process for all e-products. The first 5 years for this system, we are providing a very basic and operational system. And in stage 2, in year 6 and 7, we can hopefully complete the study. And then at our task force or at this committee, we can share with you the information and then confirm it. I cannot reverse time today. That is what I can do in terms of the timetable. Why don't we think it is suitable to write it into the bill? I'm not a lawyer, but when we draft a piece of legislation, we must be very clear to prevent any dichotomy in interpretation. So if it is something very conceptual instead of a very concrete proposal, we can't really write it into the bill. If you're worried that the government does not go ahead with it at the end, we can provide other information papers showing you our commitment. Thirdly, Dr. Leung said, well, clause 12 bracket 6 is the right place because you are talking about consent for shareable data, so why not just add something here and say the patient has a right to retain certain information or data not to be shared. This is my understanding of what Dr. Leung has said or suggested, one possible place for this feature to be incorporated. But if we do that, in different countries at the moment, they allow the option to the patients to conceal all the data or disclose all the data, just like Australia. In the first year, you can conceal certain information. And then they decided drug allergies, so on and so forth, cannot be concealed. And the UK came to a similar conclusion. So if it is up to the patient to decide what information he or she wishes to conceal, we are jumping one step ahead to the design of the option. Perhaps we can learn from the Australian model and understand that certain information cannot be concealed. Then this will become problematic. Or in other countries, the patient will have the final say, and then other countries, as a physiotherapist or occupational therapist or as a doctor, I can consult the patient and I decide on what I want to write down in your medical records. So it is not the patient that has the final say. Once the patient provides consent, we are jumping ahead to the design of the option again. So I don't think it is suitable to write anything in the bill concerning this concept, but we can provide written undertaking elsewhere.
Yun.
Dr. Leung Kalau. I don't care whether or not you have incorporated the design of a safe deposit box in the future, but then if you just look at 6A1 and 6B1, just looking at these two clauses, which offer the patient a choice as to whether certain information should be included. So even if there is no safe deposit box in the future, I think that's very important because at present, DHA doesn't include all the information there. For example, for follow-up consultation records of the psychiatry, all right, that's not included. For example, in my case, I would be inputting all the information in the database. For example, for PIOS, many people have this problem. But then for psychiatric records, well, other than the fact that it's about the diagnosis on the patient, he might also have included many strange ideas that the patient might have. For example, his perception of certain people and so on. So some of these might be very strange or bizarre, and therefore the current practice is that the psychiatrist would not input all the data in the records. So he would just keep it in a separate hard copy. So that is a way of respecting the privacy of the patient. Alright, if it is drafted as it is here, alright, there might be certain information that the patient doesn't want other people to know. But once he has given this consent under the EHR, so that for other HCP treating his other symptoms, for example, diabetes and so on, alright, for one reason or another, DHA might have included some information that he doesn't want other people to know in the database, and that would be against the wish of the patient, and therefore I think this point is really worrying. The reason why I've raised it here, so you can take the opportunity to make it clear, because at this juncture you can also do this so that if you're going to go electronic, then you may not have to amend the provision at all in the future. But then even if after the study, after you've taken a decision on whether or not you're going to have or not going to have a safe deposit box, I think you should also make it clear here. That is, the patient should be given a choice as to whether certain information should be included. For example, whatever you do, the psychiatrist would be manually recording data in his records, because he will need to know everything, because even himself would find it difficult to follow up on the patient if there are no such records in his hard copy. But then you should allow the patient to make a specific choice. That is, I don't want you to include certain information in the system. Even if there is no safe deposit box in the system in the future, the patient can still make a decision as to whether he would allow certain information to be included in the system. But then once he has given this consent, by error or mistake, it might just be a computer system breakdown. Then if certain information is disclosed, then there is no way that the patient can go after anybody for liability or damages. So as we move on, apparently what you're prepared to do is still some distance from what members would like you to do. I don't want to make it difficult for you to come to a decision. So with regard to what Dr. Lau just said, would you be making a decision, or would you be fine-tuning your thought, or do you have to go back and think about it? Apparently what members just said was somewhat different from what you're prepared to do. I think, Chairman, we have to separate it into two parts. That is the direction that we are going to take in considering this package. I think members would be more inclined to adopting a more positive approach. That is, it's not about whether or not we're going to do it, it's about what should be included in the package. So I think for the first half, I think the distance between us has been narrowed. So the gap has been narrowed. But then the second part is about whether or not the so-called safe deposit box concept, is it appropriate to include it in the bill? And our current thinking is not appropriate. But then according to some members, they think it's appropriate to have express provisions on this. And Dr. Lau was suggesting that with or without such a provision, if you look at clause 12(6)(a), if the patient has made it a point that doctor, you should not include this in the database, and if the doctor still ignores his wish, then it's not good enough. So you can keep it in your hard copy, but then you should not be sharing it in a platform so that everybody can have access to it. Because once you have given the consent, then everyone else in the HA or in the system will be able to have access to it. So either the patient says that, doctor, you should not write it down, or the patient should be able to say that, doctor, please do not include that in the platform. Well, with or without this system, when you see a patient today, and if the patient makes such a request not to include certain information in the records, then what will the HA do, or what's the requirement of the medical association? Who is to answer this question? Dr. Wong? I think the current requirement is that the doctor has the duty to keep an accurate record, and therefore we will have to look at the circumstances. All right, we have listened to the wish of the patient, but then keeping an accurate record is the code imposed by the medical council. But then whether or not it should be kept in an electronic system or in the form of a hard copy, well, there is no specific requirement, because the medical council has not got specific provision on this. And if the doctor is seeing the patient on a personal basis, then of course keeping the record in a hard copy would be okay. But then if it's a team of doctors collaborating together in treating the patient, then keeping the records in electronic form might make it easier for them to share the information and to communicate amongst one another. So that's the purpose. Can you supplement on this? Yes, Dr. Wong. Under the Medical Council's Medical Practitioners Registration Ordinance, the Code of Conduct requires the doctor to keep a full set of record, and also the healthcare provider would also be required to keep an accurate and up-to-date record of the patient. So that's under the code of the law. And in the course of the contact between the doctor and the patient, and if the patient doesn't want the doctor to include certain information in his medical history, or if he doesn't want to share certain information with other healthcare providers, then the doctor will have the autonomy in determining the way in which the information is stored or kept. I'm not suggesting that the patient would have the right to ask the doctor not to keep certain records, because under the code of practice, in 3 months, if the information is not written down, then the doctor will have no way of recalling it in future consultations, and therefore the patient does not have the right to ask the doctor not to keep certain records. But then the patient should have the right to ask the doctor not to share the information with anyone else, including this EHR system. But then the way your provision is drafted, alright, the doctor can just decide to input the data in the system. Would the medical council be punishing the doctor? Because the medical council requires the doctor to keep the records. But then if the patient requires the doctor not to share the information with others by not including the information on the system, then can the medical council punish the doctor for his failure to take heed of the request by the patient? Yes, the doctor can decide what information to be included, but then whether or not the patient can request the HCP to keep the information confidential without sharing it with other healthcare providers. Alright, under the current EHR, the same thing can happen. And therefore, even without the new bill, and even without the newly added provision as suggested by Dr. Leung, we will still be able to achieve the same effect. That is, if the patient requests that the doctor should not include certain information in the database, then the doctor, if he thinks that there is a need to record such information, he can always keep such information in other formats without sharing it on the platform. So even without the new provision, the doctor can still do it under the current system. In other words, what you meant was, well, under the code of practice for the doctors, he will have to take heed of the request of the patient, and if the patient does not want the doctor to include certain information in the records to be shared, then it's already okay for the doctor to do so. Alright, the code says that the doctor will have to keep the record which is accurate and up to date, but then under the circumstances, well, the honorable member just said that it's already happening. That is, if the patient only wants to provide the information to the consulting doctor, but then he doesn't want the information to be shared to other healthcare providers, then as suggested in some systems, the records would only be shared amongst those who have enhanced access to the system, but not the others. So in the future system, well, not all the information will be shared, but then even for the information under the system, is it possible for us to do what the member just suggested? That is, can they preset that certain information will not be shared? Will that be able to achieve the same effect? That is, for certain confidential information that will not be shared under the EHR system without having to introduce a new clause? Yes, Mr. Chen? In fact, the way 12.6a is drafted, alright, we'll be doing the clause-by-clause examination later, but then if you look at the way 12.6a is drafted, alright, if it's a clinic or a hospital, if the patient has given consent to share their information, then the clinic or the hospital can provide certain shareable data through the system. So that's the way it is drafted here. It doesn't mean that after the patient has given the consent, then the clinic or the hospital must provide all the information about the patient in the system. For example, let's say if the HCP is a physiotherapist, and when you see me, alright, I have 9 types of data, and there might be types of data that I will never need to have access to. And in some circumstances, I might have to contribute some information to the system. I may have to install certain modules. Some private hospitals have attempted to install such systems in order to have those modules, and only with those modules will I be able to have access to the system. But then if the hospital or the clinic has not installed the modules, then even if the clinic or the hospital would like to report the information to the system, the clinic or the hospital would not have breached 12.6a, because the law does not require them to report everything to the system. So the system just allows you to input the information in the system. It doesn't say that you will have to input all the information that you know in the system. So we do not believe that it's like what the patient will be asking the doctor, all right, for this part, you can only write it down in handwriting without inputting it in the system. So both ways, it doesn't breach the law. Yes, Dr. Leung? I'll give you a bit more time before I ask another member to speak. Yes, point noted. Alright, if a patient is seeing a psychiatrist, alright, he tells the doctor that, alright, what I'm going to tell you, you can only write it down without putting it down in the e-system. Alright, if you agree, then I'll give you the consent. And then afterwards, for whatever reason, okay, so the doctor has inadvertently inputted the information in the system. So has the doctor done anything wrong? Alright, in seeing the patient has given him the consent that he can input certain information in the system, even though the patient has not given him the consent to input everything in the system. So I think you should make it specific here. That is, the patient can decide that certain information must not be input into the system. And if the power is vested in the patient, then the patient should have the power or the right to ask that certain information must not be included in the system. Alright, if I enter the information in the system, there is no way that the patient can go after me for liability. Then you have breached your promise with the patient. No, I have not violated my promise with the patient, because the patient has given me the written consent on e-sharing. So how can you say that I've broken my promise with the patient?
There is written consent to share data, saying that I can place it on the system, so I'm not violating anything. Any precedence at the medical council once you give the consent for sharing, but you add one more thing, saying that can you not place it on the system, and then other people still place it on the system anyway. What you have been talking about is really about the practices in the code of practice. Perhaps we need to gather more background information and see if it really offers protection to the patient. Which one should take the precedence? Chairman, I would like to propose something. Dr. Leung is no longer talking about the deposit box feature. It is about 16(6)(a)(1). If the patient says that do not place information on the system, and then the clinic or the private doctor does it anyway, perhaps we need to go back and work on 16(6)(a) and see what the potential risk may be. I agree. Even if you do it, it cannot replace their demand for incorporating a feature of the deposit box. Next, Ms. Sit Ho, and then Ms. Wong Bik Wan. Dr. Leung Ka Lau made a proposal on how to incorporate the feature. It is about patient's choice, and it also affects the trust between patients and doctors. He used an example of a mentally ill patient with hallucinations affecting others. If you place it online, it may be very convenient for other HCPs, but it is not fair to the patient. For example, someone sees CY Leung on TV and he feels sick and he wants to vomit. And this person turns out to be a senior government official. He does not tell anyone about this. So the safety or safe deposit box or the provision proposed by Dr. Leung, we must leave some room to the patients to decide for themselves. At this Bills Committee, we talk about medical records not just for the HCPs, but also for the patients themselves. If the patients can obtain information very conveniently, if they do decide to move away from Hong Kong, they can just get everything from the safety box and then take it with them. They don't have to go through more trouble. For example, writing things elsewhere on paper. So their records can be kept in one place. Okay, perhaps we can listen to the next member. I think when we reach 6 p.m., well, I feel quite sorry that we need to ask the Commissioner to keep coming back. That is why we have allocated 3 hours for this meeting. So please watch the time. Mrs. Ho? The officials said that they can consider doing it, but not now. This is version 1.0. They have to wait until 8.0 to do it. Something like that. You have to wait for many, many versions. They talked about 1, 2, 3, 4, 5, 6, and then 7, 8. So I'm worried that we have to wait until version 8.0. Members here are in favor of this feature. Perhaps the objections will come later. Well, not today. They're not among the members present today. If you agree, all the parties agree, we can amend it. The Commissioner can also propose his version, and we can look at it. If this is what everybody wants. There are members from the FC, from the Alliance of the Government, and also Pan-Democrats are also here. If we all agree, you have enough votes to endorse it. So instead of spending 3 hours and another 3 hours, perhaps the Commissioner can do something, because you also have a team of legal advisors. You understand very well this concept. Perhaps you can propose an amendment to the bill, providing more than just a directional concept. Then we have something more concrete to follow up on. Otherwise, members may have to think about moving an amendment. Ms. Wong, Chairman, we have been talking about the concept of the safe deposit box. We just want to make sure the patient has the right to decide if information is to be disclosed or concealed. We support this concept. But it sounds like the government doesn't want to do it. They sound very reluctant. So in principle, do you agree with the commissioner or members that we should give the final say to the patients concerning what information should be provided to the system? Perhaps only to some doctors. Do you object to that in principle? If not, then we just need to work on the operational details. The commissioner can write a version, we can amend it, or the best way is, of course, for the government to amend it, add some additional clauses or provisions, or amend the details in this copy. And then we can have a debate. So at this stage, do you object to that? You only want to do it in a next stage, or in principle you object to it and you don't want to do it anyway? Well, they actually responded earlier. Perhaps Mr. Chen, you can reiterate your position. Earlier in the meeting, I have already said that we would like to clarify that the government never said we definitely don't want to provide this safety deposit box feature. This is a 10-year plan. The first half has already gone by. So for this to happen in stage 1, it is impossible in terms of timing. So the only thing we can do is to move ahead with a study. And then in year 6 to 10, we can complete the study. And then based on the results, we can come up with a design. That is what I have stated earlier. It is not true that we have already decided not to do it. The study is focusing on how to do it instead of whether or not we should do it. Secondly, members here support this, but in 2012 and 2014 consultations, many groups, especially Medical Association, Dentists Association, and groups representing HCPs expressed grave concerns because this feature may lead to risk for the patients, or HCPs may have to shoulder legal liabilities due to not knowing certain information about the patients. They have reservations and objections. They are our major stakeholders, so we must come up with an option that is acceptable to the patients and also the HCPs. That is why this study is not that straightforward. If we refer to overseas examples, we have not seen any success stories. So for us to come up with a package that is suitable for Hong Kong, it's not something that we can complete within a month. So we can only undertake that we will do it right away next year. We'll do the study right away. And when the results come out and all the stakeholders agree, we can implement it in the following year. We don't have to wait until the 10th year, which is the end of the second stage. So this is what I have said. This is one thing. The other thing is, if we are to provide this feature to enhance the power of the patient, do we need to write it in the law? This bill is technically neutral. There is no description about the design or the architecture of the system, whether we use internet, intranet, with a central server, or do we store the data in various places. We intentionally choose to do it so that technological advancement will not be limited by such provisions. We will continue to add new functions to the system, and that's why we don't want to write it down in the bill. If we write down something like a safe deposit box, whether there is internationally agreed definition, perhaps if you bring it to the UK and Australia, people won't understand. So it is difficult to write the concept into the bill. For 16.6A1, perhaps you're saying that there's a lack of protection for the patient. We will go back and examine clause 12.6A1 again. So we are willing to undertake to follow that direction to conduct the study and as soon as possible provide the results of the report or results of the study, but we don't think we should write it into the bill. If we agree in principle, the law should uphold that spirit and the provisions should fully demonstrate or realize the rights of the patients concerning what information can be placed on this platform. When it comes to technical operation, year 6, year 7, that is a technical matter. But if you look at the provisions, whether the law allows or ensures the patients having the final say, we have to write it into the bill. Otherwise, you have the technologies, but then the law doesn't allow anything. Wouldn't that be strange? So there will be amendments to the bill in the second stage, because at the moment the bill is technologically neutral. If we are to add different functions, for example, in stage 2, X-ray slides can be shared, so on and so forth. We don't need to amend the law. The law won't preclude the addition of such clauses. I think Mr. Chen has already provided a very clear conclusion concerning the government's stance. Ms. Sidho proposed one thing. If the government does not want to realize this direction in the bill, maybe members or the commissioner can provide some views and consider proposing an amendment. The best way forward is, of course, for the government to move amendments. So does the commissioner have anything you would like to add, or any further views you may put forth to facilitate the amendment? Because you started off with that thing when you first came in. You said that when a function is not to be incorporated at this stage, we should write it into the bill. That's what you said on the outset. Do you have any more concrete materials in writing that can be provided to us?
Commissioner, thank you, Chairman. I've been listening very intensely to what the administration just said. I think they've been very careful in their wording. They said that they had never opposed the idea of a safe deposit box, but then at the same time, I haven't heard them say that they are prepared to implementing it. All they are saying is that they have heard different voices. That's why they have some reservation about this. So my understanding is that with regard to what they are going to do in the study, they will try to resolve the problem of the opposition that they are aware of. If that is the case, then I would be concerned, because instead of trying to foster 100% consensus, I think they should be doing something about it. All right, we agree that different countries might have different practices, but then from my perspective, I think what we are insisting on is that we should try to learn from their experience as to what we are borrowing from their experience. I agree that at this stage we don't have to make a decision. That should be left to the next stage, and using their own wording. The autonomy should be given to the patient to withhold or hide certain information from the HCP. That's all. And you talk about technology neutral, and I fully agree with that. So all we need to do is to prescribe the concept, and of course we should not just be putting in the 3 words a safe deposit box, but then we all have to agree that this is the idea that we are going, this is the direction that we are taking, and then we should put it down in writing, and then we can have something to hold on to in black and white. And if you want us to help with the drafting, then we'll be happy to do it. I think some members have already made a request. They'd like you to help. Elizabeth Quat. I think we have already spent 1.5 hours on this, and we have 2 more points to discuss. And while the Commissioner is here, I'd like to take the opportunity to discuss those issues too. So, Ms. Kwok, after you have made your point, I think we all know our stance. I think we can move on. Yes, Chairman, I agree with what the Commissioner just said. I think he has spoken most of what I'd like to say. What I'd like to say to the administration is, in fact, your reply disturbed me even further, because my impression is that you're trying to drag your feet instead of doing something concrete. That's why I insist on reflecting this in the provision. It's not just about the word safe deposit box. It's about the overriding principle that we are asking. That is, we have to protect the autonomy of the patient and the patient's right to withhold certain information. I think you've heard a lot, but then you still decide to turn a deaf ear to this. We have never asked you to put in some technical things in a provision, and we have never asked you to put in the words safe deposit box in the provisions. And if you're not even prepared to study it, and if you just say that you do not agree that we should include or incorporate the concept of safe deposit box in a provision, I think you've already got a stance. That is, you're not willing to do it. So I think you should work it out with the Commissioner, and if the administration decides not to do it in the end, then I will definitely be moving my own amendment. Okay? So I think we have had sufficient discussion on this 4th point, and administration, please go back and see if you can come up with some response next time, because we will have to sort this out before we move on to clause by clause. So I think we will need to discuss this further with the administration before we move on to the next stage of our meeting. Point 5. On the 2 offences. So, Mr. Chen, before I ask the Commissioner to respond, well, the Commissioner would like to see if new clauses can be included so that new offences can be created. First, well, even under the Personal Data Privacy Ordinance, if you access certain personal data without authorization, well, is not against the law right now. And under the EHR system, actually we have already taken one step further. If you access certain information without authorization, we have already turned it into an offense. And the Commissioner is suggesting that if a person has accessed the information via a computer, is an offense, is good. Then how about making it an offense if it's an unauthorized access to information by non-computer means? So I think that's the suggestion by the Commissioner. Is that right? Can the Commissioner confirm whether this is what he is suggesting? So have I got it right? Yes. One is about access and the other is about use. And the head just said that is about access to the information. And the second part suggested by the Commissioner is that in terms of the offenses, all right, if you've used the information for direct sales, so that would be an offense. And he also talked about other forms of misuse. So can there be an umbrella provision so that for other forms of misuse, if they can also be turned into offenses, then that would afford greater protection to personal privacy. So is that what the Commissioner is suggesting? So that's my understanding of the Commissioner's suggestion. Now coming back to the administration's stance on this, on the first point, the reason why in the bill, given the fact that in the past unauthorized access to information has never been made an offense, why is it that we are proposing that unauthorized access to the information via the computer is an offense? Because we're talking about an e-system. And therefore we'd like to punish hackers who have accessed the information without authorization, we'd like to punish them. That's why we have got this provision. That is, if you access the information via the computer without authorization, then it's an offense. And therefore, the Commission is suggesting that what if I access the information by non-computer means? For example, if I copy it by hand, i.e., I'm not using the computer to access the information, why is it not an offense? But then, since the bill is about EHR, so the sole purpose is to regulate the system and how it's used. So for other forms of access to information by non-computer means, should it be regulated by this bill as well? This is the first point. And secondly, well, using the example cited by the Commissioner, all right, if a doctor forgets to log out from the EHRSS and a third party gains unauthorized access to the EHR by looking at the screen, and if we were to incorporate the recommendation by the Commissioner, then that would be an offense for that third party. But then we have to be very careful about this. All right, precisely because that third party just passes by and he just takes a look at the screen. He has not obtained the information and sold it to the third, fourth, or fifth party. He just takes a look at the screen. Should he be punished? Because there is no mens rea on his part. Because the previous threshold would not be that high. All right, there must be two steps. Number one, other than having access to the information, you must have done something else. That is, you must have made profit out of it, or you might have misused the information before it will be an offense. And we believe that under the circumstances, we should not be strengthening or enhancing the penalty simply because the person has gained unauthorized access to the information. And also, in terms of law drafting and in terms of law enforcement, we hope that the acts that we would like to punish, they should be described in more specific forms. For example, whether or not it's extortion of money, or whether or not it's assaulting people and so on, because of the way it is specifically described, it would be an offense. But then, if it's just about a general misuse of the information, then in determining whether or not the person should be found guilty, it would be somewhat difficult. And also within Hong Kong system, the same organization would be the law enforcement agency, and at the same time it will be the authority which will be imposing the punishment. So very rarely would that be done, and that's why we have some reservation about introducing the clause as proposed by the Commissioner. Commissioner, any response from you first before we open the floor to members? Well, there are two parts here, Chairman. On the first part, on access to the information without authorization, just now the administration said that the purpose of the bill is to regulate the EHR system, and therefore our suggestion involves access to the information by non-computer means, whether or not that should be covered by the bill. But then I can also remember what the head just said. I think the ultimate objective of the bill is to afford protection to the patient with regard to his privacy and health records. That's why you should look at it from the technology neutral perspective. You should not mind too much whether or not it's done through electronic or non-electronic means. So long as it's an unauthorized access to the system, there should be appropriate punishment in order to deter such acts. Because after all, the purpose is to protect the person's privacy. I think that's more important than what technology you apply in accessing the information. That's point number one. And number two, I'd also like to clarify that we are not talking about an ordinary person passing by and inadvertently having access to the information on the screen. No, that's not the case. We are talking about someone trying to do it deliberately. The only difference is that he is not accessing the information by computer means. And last time when we submitted our submission, we have already referred to that. And just now, the administration said that compared to the existing PDPO, all right, is a bit harsh, because under the PDPO, for any access to personal data without authorization, indeed, under our ordinance, it doesn't constitute an offense. But then, I'd just like to say that the bill under discussion is about a patient's health records. When compared to general personal data, we should afford greater protection to such data. In fact, 3 years ago, under the PDPO, during the public consultation exercise on the amendments to be made to it, in our concluding statement, that's the findings in our consultation. In fact, there might be different types of personal data, and for certain types of information, the protection should be enhanced. But then 3 years ago, when we amended the PDPO, we were not able to do it, because other than patient records, there are other types of sensitive personal data. That's why the administration said that there wasn't yet a consensus on a formal classification of different types of information. That's why it did not do it. But then today's discussion is very clear. We are not talking about any type of personal data. We are talking about patients' records. So when compared to general personal data that we discussed 3 years ago, we already confirmed that we should be affording greater protection to this type of information. That's why my suggestion was based on this. And coming to the second part is about misuse of information. The administration said that in other pieces of legislation, there aren't specific examples of non-specific misuse which would be subject to punishment. In fact, that's not true. We have also given some examples. For example, the electoral affairs or the electoral legislation, all right, for voters' information. If it's not used in an election, then it's already a misuse of the information. Then under the electoral legislation, it's already an offense. So when it comes to voters' personal particulars, when compared to what we are discussing now is about patients' records, I think we can easily come to a conclusion that is a patient's personal data would be even more sensitive. And other than ID, card numbers, personal address, there might be occupation included in the voter registration record. But then for e-patient records, we are talking about pretty sensitive personal data. That's why under the current law, for voters' information or particulars, we have already got such an offense in place, and therefore we should take reference from that when we look at how we should punish misuse of patient data. Dr. Leung Ka Lau, when it comes to offenses, we have to be very careful. When you talk about access to information within a hospital setting, all right, at the canteen or in the dining corner, there would be a corner designated to doctors in this day and age. When we say that everybody has to be equal, some people might not agree to that idea. That's because for doctors in that corner, they would definitely be discussing information about their patients.
And they don't want others to hear such information. I have a question when it comes to medical records. There could be many different versions. According to the Commissioner's proposal, inside this e-system there will be e-records or some previous hard copies coming from some HCPs or other HCPs who have downloaded copies from the e-system. So how do we define data from this system? Data is data. There's no way to tell. You can obtain the data through different channels. They can be circulated among HCPs. They could discuss them when they are having their meals. If I'm sitting at the next table and I try to listen to such information or discussion, is that dishonest way of obtaining the information? So perhaps the data is printed out. How do we decide? which data is from that e-system. The chairman also talked about gaining access to a computer with criminal intent. And it seems that, well, perhaps you can tell us, is there any overlap which are related, which are unrelated? Because the penalty can be 2 years imprisonment. And it could go up to 5 years. So can you explain what is the relationship between this and also Cap 200 Section 161? Maybe we can ask the Commissioner first. How do you tell the source of information? And what about further copies? How do you segregate them? Thank you. So we collect information within the system, and then it could be circulated. If you are just having a chit-chat without any particular records, that is not personal data under the ordinance. If you're just chatting, it's not use or collection. But once it is recorded and circulated, you talk and then I record it or write it down, that is use of information. Otherwise, it is not use of personal data. So that is the trick in this bill. And when it comes to personal data, of course, it has to be relevant to a certain person. If you just say a certain patient with a very common symptom, you're not naming anyone, you're just saying a certain patient. It's not unique symptom coming from the patient, then it doesn't concern collection or use of personal data. And Chairman, when we talk about offenses, we may be quite worried that perhaps they are too harsh. We have mentioned that there are more lenient ways to deal with offenses, perhaps not so commonly done in Hong Kong, but there are civil penalties. Just a fine, but no imprisonment. So there's no need to worry that the bill may be too harsh. This is actually done elsewhere around the world. There are different ways to penalize people violating the personal data privacy. Dr. Leung, you are frowning. If we have a chit-chat at the table, it is really about how to handle a certain patient, and we know which patient we're talking about. After such communication, and then a patient is treated in a certain way, it is not the same as just chit-chatting for academic purposes. We are really discussing how to handle a certain patient. So the Commissioner said that written information is recorded. What about orally spoken information? The Commissioner seems to suggest that according to the ordinance, they are not considered as data. You have to put it down in writing, right? If you are just talking, it is not collection and use of personal data. What if I read out the ID card number of a patient? It is not collection or use of personal data. But when you say it and then someone puts it down and then circulate it afterwards, it is. So the writing down is collection of personal data and circulation is use of personal data. So I'm talking to my colleague at the table, dining table. And when I see the patient and I write down something that means collection of data, yes, from that moment on. So what is considered as data? What about the second part of the question? Improper use. I would like to address the second issue first. Right now, in the law, we are adding a few offenses. For those parts that do not offer any waiver or exemptions, and all other relevant laws will apply. For example, dishonest use of computer has been relied on to sue people who have obtained information from computers to do criminal act. So, which ordinance will the prosecutor choose to rely on? I think it is up to the Department of Justice, depending on the details of the case. I think my colleagues from DFJ can explain further. So similarly, on the first question, as long as no exemptions are offered in this bill, you have to follow all the requirements under the Personal Data Privacy Ordinance. 3 years ago, there was a round of consultation hoping to amend or add certain penalties. When it comes to more sensitive information or data, whether we should offer better protection and increase the penalties. At the moment, we felt if they are sensitive in nature, we should add something. Should we rely on data protection principles, something that is not laws? The views were quite divided, and that's why 3 years ago we never reached the stage of amending the ordinance. And so far, if you access information without authorization, it is not an offense exactly because of that reason. The scope is very narrow. We are just talking about e-data inside this electronic health record sharing system. If a person who is not a hacker uses a computer if a person hacks into the system to obtain information or read information without further action, there's no profit making, he does not spread the information, perhaps we should leave it to other ordinances to handle this situation. But if the Commissioner thinks that medical record is so sensitive, they don't just appear in this e-system. There are doctors writing down medical records. In some hospitals, they have their own medical records. So even when we amend the bill and add the proposal from the Commissioner, we are just amending a little bit inside this EHR sharing system for other medical records accumulated in other places, they will not be protected. So if we are to offer better protection for medical records, perhaps we need to amend the privacy ordinance on medical records. Once that is amended, we will have to follow. I think that is better. Otherwise, you're just protecting e-data in this EHR sharing system. You are not providing comprehensive protection to people's medical records. Dr. Lau? So can you tell me where the intersections are, where they overlap? When do we rely on this ordinance and when do we rely on the other ordinance? DFJ colleagues, in this bill, there is this offense of dishonest use of the computer. This EHR sharing system bill will not make that provision inapplicable. Which one we need to rely on to prosecute someone? Should we use the dishonest use of computer or under this bill? It really depends on the prosecution lawyer to see which one is more suitable. If either one is more specific in targeting the facts, he will rely on that one. According to my knowledge, when we worked on the offences under Clause 41, we have taken reference of dishonest use of the computer. So the penalty level will not be more lenient, and the maximum will be 5 years imprisonment. Offences in our bill are actually more comprehensive. We're talking about gaining access, modifying data, or impairing the operation of the system. So the offences spelled out in our bill actually covers a wider scope. Dr. Lau? Well, I'm asking about this because if all the offences here are already covered by dishonest access of computer data, this part is obsolete. The entire ordinance will become obsolete. Why? If you write a bill there is already an e-medical record system in the hospital authority. So at the administration level, as long as the system allows medical institutions and doctors to share the data, you don't need to put down any law. You can just rely on administrative means.
So one of the important reasons for enacting this law is to protect the patients and protect privacy. That's why you have come up with these offences. I think the most important part of the bill might be the offences. But then if you're still not able to distinguish this offence with the other offence, whether there is any overlapping or whether you're complementing each other, or if part of it is already covered by that provision, then the whole bill is superfluous. So, Chairman, he has not been very specific in answering or giving us the details, and I don't want to take up too much time of the other members. So can you just provide us with a simple table? All right, you have so many offences here, and if you can list them out, telling us that, these can only be prosecution can only be instituted under these provisions, but not the other one under the crimes ordinance, and also the penalty would be somewhat different. So if you can set that out in the form of table, telling us that certain X can only be prosecuted under this bill and not the other, and whether there are certain offences that can be prosecuted under both ordinances, then that would help. Can you do that? Yes, I'd also like to supplement what Dr. Leung. I think it's better for them to enact this law than relying on that ordinance, because I would be even more worried than you do. Because recently, my concern, and I also like to, I might as well voice it here, because with regard to access to computer with criminal or dishonest intent under the crimes ordinance, I think it's too broad, and I think it's been abused. Yes, Chairman, I'm trying to help you, because the original intention is 20 years ago when it was first enacted. The purpose is to target acts that were meant to be in preparation for certain criminal acts, and I was about to go back and take out the old discussion papers and files and so on in order to take it up with the administration again. Alright, they will have to spell out which offences have not been covered by that provision. Yes, some members are of the view that that provision has been abused right now. Just now, they said that altering the information would not have violated that provision. Well, let me finish. Well, my view is that if it's about e-health, then you should rely on the spell to prosecute the persons instead of that one. Alright, for falsifying documents, you should invoke the relevant ordinance, and then for sex offense, you should rely on the relevant legislation instead of trying to make use of that, which can be abused very easily. That's Section 161 under the Crimes Ordinance. I think, Mr. Young, I'm somewhat concerned by what you said. Yes, in fact, I like your answer, because just now you said that your prosecution principle is that whichever provision is more specific would be relied upon in taking up prosecution. Regrettably, just a few weeks ago, the Secretary for Security, of course, he does not represent the DFJ, but then he is speaking on behalf of the police, and he said that whichever offense would be easier to convict would be invoked. He was answering a question from Ms. Sit-Ho. In fact, I like your answer more than the one he gave. I think that would also affect Dr. Leung's decision and also his safety, because he's concerned that people might abuse the provision by prosecuting him or by suing him on that basis. And you also talk about modifying, impairing the system and so on. But obviously, under Section 161 is very broad. It's about access in a very broad sense. So anything to do with access could be caught. So my comment is that in the future, when you enforce the law, I hope that that can be put on record. That is, if it's about any contravention under this ordinance, then prosecution should only be instituted under this ordinance instead of relying on that provision simply because it's easier to prosecute. All right, thanks to Dr. Leung for raising this point. Well, if you do not access the information, then how can you modify and impair the system? Well, I think access would definitely be a lot broader. Yes, we'll end by 7:30, sorry. So it depends on how many of you are prepared to stay until 7:30. Maybe just you and me. Then our last item, Elizabeth Court, if you're willing to stay, then we'll be able to discuss that. Well, we can't ask the Commissioner to come back time and again because it's not fair to him. I'm afraid the Commissioner might have to come back again. Well, on part 5 is about offences. I think a lot has been set out here, but then the administration also said that access to the information, if I turn on the computer if a third party access the information by accident, then it should not be an offense. But then what if he takes a picture and then he has not used it for direct marketing? But then if he has seen that picture, or if he has hidden some personal particulars, all right, let's say if that's a celebrity or a pop star, and according to what you said, only those that have been expressly provided for here would be caught, and then for unauthorized access by non-computer means, that would not be an offense. So what will happen? Will that go to the commissioner for follow-up action, or what? So this is a hypothetical situation. What if a person gains access to some information by non-computer means? What if he takes a picture of the screen, and if he hides certain information, but then he still shares the information with others? You will be able to guess who this pop star is. Then has he broken the law? Which offense has he committed? So, Commissioner, can you tell us more about this? All right, this is a hypothetical situation, and therefore I can only give my general comment. All right, I think that has violated the Data Protection Principle 3. So, the purpose of collecting the personal particulars, all right, as far as the EHR is concerned, is for the provision of healthcare services, is to improve the healthcare services rendered. But then in the end, if it's uploaded onto the web for gossiping purposes, then I don't see how it can be related to the EHR system, and therefore you might have a breach DPP number 3. In other words, it's an offense, right? So what about the penalty? How would that be dealt with? If somebody files a complaint with you on that, then what will you do? Well, very little can be done. The only thing that we can do is to issue an enforcement notice asking the party to stop the relevant act, and if he continues to do this by flouting the order, then we will see what action can be taken. But then it depends. If that person has to do with a hospital, all right, and the owner of the personal data is the hospital, and if the hospital has gains access to the information without the consent of the data subject, then there are two circumstances. One is for profit, all right, it has sold the information to a third party for a profit or benefit, or if it's not for a profit, but then if it causes damage to the data subject. For example, if it's uploaded onto the web and it's just for publicity without causing any substantial damage to the person or the data subject, then either is for personal gain. Second, if it causes damage to the data subject, then under the amended version of the law, it would also constitute an offense. So it would be conditional on what I just set out, and then the person can be convicted of the offense. Chairman, what I'm interested in, as the Commissioner just said, all right, the existing provision does not afford sufficient protection to the data subject, but then the administration says otherwise. So can the administration tell us whether or not the bill will be able to deal with the situation or the act as described by Ms. Quat? As the Commissioner and I have explained before, all right, if a person gains access to some information without authorization, all right, if he just passes by a computer screen, well, if he just takes a look at the screen without disclosing the information on the internet, or spreading it to 50-60 person, or using the information to blackmail the data subject, then today he might not have committed an offense. In other words, under the PDPO, without this piece of legislation, all right, under the PDPO, he has not committed an offense. That's why I said that we had already taken one step further. That is, if he had done so via the computer, all right, he does not have the authorization, but then if he gains access through the computer. Alright, if there is a hacker accessing the information without authorization after this bill is enacted, then if I take a picture and if I access the information without authorization, well, it depends on whether or not the camera would be defined as a computer. Let me clarify. Alright, the way you put it, with this bill enacted, then if I access the information via computers, so you're talking about gaining access to the information. So whether or not I've taken pictures or whether or not I've used it for any purposes, I would still be committing an offense. Is that right? If you have accessed the information via computers, even if you have not used it at all, if you are an employee of the HA, you do not have authorized access to the information. If you just pass by somebody's seat or workstation, and if you have access to the information via the computer, then you have committed an offense. But then the commissioner is suggesting that if the access is unauthorized, and even if it's not by computer means, it will still be an offense. But then I am saying that it has gone beyond the scope of this bill, because supposedly this bill is only regulating an electronic database, and only those who have access to the EHR system would be regulated. But then if it's just about a patient's medical records, most of them would not be incorporated in this, because only 9 types of information would be protected. For the others, they would not be protected. For example, in private hospitals or even in public hospitals and clinics, they would also have some handwritten patient records. So even if I enact this bill, I would not be able to regulate that. That's why the root of the problem is to amend the PDPO, and once it's changed, I will have to make corresponding amendments. Well, I think that's somewhat different from what you said in the PowerPoint, because the way you put it here, that is the Privacy Commissioner thinks that is a piece of sensitive information. That's why it should be protected. But then if there is no mens rea, then it's not appropriate to make it an offense. But then according to what he said, so long as he has access to the information, as he has not got authorization to access the information, so long as he can see it, is already an offense. So I don't quite understand, because apparently what you said is different from what you have written down. No difference, no conflict at all, because originally what has been added is if you gain unauthorized access to the information via computers, then it would be an offense. But then the commissioner is suggesting that even if it's done by non-computer means, it should also be an offense. It doesn't really matter, because the original intention is to target those using the computer. But then you talk about mens rea, if there is no malicious intent. So even if he has not taken any pictures, if he has done so, if he has accessed the information, alright, if he has just copied it down by hand, if he has not sold it for direct marketing and so on, if he has not taken the second step under our mechanism, then it would not be an offense.
So he has to read it and then place it online. That is an offense. If he just memorizes it or hide it at his home without a second step to victimize anyone, it would be too draconian to penalize him. What about the commissioner? How do we introduce a new offense to allow better protection? I can give you one example. I hope that we can understand better. Gaining access through non-computer means may also violate privacy. There is a real case for the IRD. Taxpayers' information has been copied down but not used. That created or constituted an offense. Improper behavior of a public officer. That was the offense. The judge felt that it was a matter of timing. He was probably planning to use the information that he has gathered. In other words, he has read and recorded the information, not yet used the information. It's still very risky. Do we need to consider that? For example, imprisonment or other penalties perhaps too heavy, then we can consider a fine. That is a background of my proposal. Well, this only targets the electronic health record sharing system. Are you talking about something outside of the scope? That's why the government is proposing the amendment to the PDPO. What is your response? That is correct, because we want to be comprehensive. And of course, we need to come from the PDPO to be comprehensive. But we are talking about this bill. Do we want to do something? Or do we wait? That is the decision we have to make. So this is going to be a huge task requiring quite some time. But I have this idea. I'm not trying to speak on behalf of the government. The people who obtain the information, the number is quite limited. But it is quite strange. I'm not sure whether taxation information is more sensitive or health information more sensitive. Because many people, many HCPs may have access to the information. How do we strike a balance? I wonder if the administration can explain if my observation is correct. It's quite hard to balance. If we want to list something as an offense, it is a serious matter. Perhaps someone is nosy. He has seen something that he shouldn't see. There should be other ways to punish this person. Perhaps a medical council or something like that can penalize this person with their existing mechanism. So it is not treated as an offense. This is why it's not always the best idea to write something into the law. This bill is just about the EHR sharing system. It is about sharing information. So we may not be able to reach the original intent. Well, I don't quite agree with that. In the past, if medical records are placed in different places compared to this shared system, the number of people covered would be very different. We want to offer better protection for people's privacy so that they can feel more assured, and more people would choose to join the system. We want it to be a territory-wide system. So this time, working on this bill, we have to consider all the details. If we see a small loophole today, the government said, let's amend the PDPO. That is not simple. It will take a long time. So when we are working on this bill, if we can offer better protection, why don't we do it today? We need to consider this. Mr. Chen? You have to speak up. Well, we want to enhance the level of protection. We have clause 41, bracket 6, that says if someone access the data or change the data with criminal intent, it is already an offense. And the imprisonment can be up to 5 years. The legislative intent is to prevent people from reading information and then use it with a criminal intent. You need to penalize them. For the other provision, they are to tackle hackers who enter the computer systems. There could be plenty of health records, and we want to protect the computer system, and that is why we have such an offense. If you operate the computer to access the information, you will be penalized. But if you are not a hacker, you don't use a computer, you don't have criminal intent, you have just read something. In that case, under the principle of protecting people's privacy, it is not an offense because the existing ordinance has been modified after public consultation. We have reached consensus on how we can protect privacy. So, should we penalize people more? Our standpoint is that we need to amend the PDPO. Perhaps we don't know if there is a consensus today, but during the 2011 exercise for the PDPO, if you refer to that report, for sensitive information, there is a lack of consensus. The Commissioner said that medical records are sensitive information and there is no debate on that. If you refer to the report and the wordings, it says that there's no consensus on the scope. How sensitive information should be managed and how we should penalize people, there is no consensus either. How do we regulate? Although we all agree that we should regulate, do we legislate? Or do we use a code of practice? Do you do more education? We need consensus. So, inside this system, we focus on protection of information inside the system. Clause 41, bracket 1 and 6 are spelling out our legislative intent. I would like to further seek clarification. If a person without authorization who should not read such e-data, perhaps he is working for the HA or in a clinic and he's reading the information, he does nothing, he does not take pictures, he does not copy anything. He just loves to read people's medical records and he reads many people's records. According to the ordinance today, is that an offense? I think you have already answered. Perhaps you can clarify further. According to our understanding, today's privacy ordinance does not consider reading information an offense, nor under this bill. And we have no plan to modify the ordinance to imprison someone who is simply nosy. What we want to achieve under the ordinance is that because we need to ensure the integrity of the health records. If you read with malicious intent or criminal intent, today the PDPO cannot do anything, but under 41(6) we add this provision to regulate that, because there is criminal intent and dishonesty is also involved. 41(6)(b), it says the person causes the action with an intent to commit an offense, with dishonest intent, or to gain personal gain, or to harm another person, then you access the information in such a way it may become an offense. So it is already more stringent compared to the PDPO. Commissioner, can you confirm that is correct? Let's turn things around then. Is it going to be too broad? Will it be too easy? For someone to be caught, intent to commit an offense, dishonest intent to deceive, how do you balance that with the actual action? For example, I have a criminal record. Perhaps it's not the best example, and I did it, and then you would see it as doing with an intent to commit an offense because of my background or for whatever reason. If it's done by another person, you will say, oh, he's just being nosy. How do you define? How do you draw the line? We are spelling out clearly 41(6)(b). You will only be caught if you meet any of these subclauses. We have to look at the evidence to decide if you have this malicious intent. Perhaps DFJ can provide some supplement. When you choose to persecute someone, you have to consider all the available evidence to see if it is sufficient to support this intent. If it's not, you cannot persecute that person by relying on this provision. So we have to see under what circumstances this person obtains such information.
So, after balancing everything, precisely because we don't want to catch people who are just taking a look at the information because they are nosy. Well, for most people, even if it's just nosy, they would not find it acceptable. Well, I have no intention of selling the information to someone else. Then why should I allow someone else to access my information simply because he is nosy? Alright, we are not saying that, well, being nosy should be imprisonable. But then, I don't think we should allow people to access our information just because they are nosy. Well, even if it's just taking a picture, would that constitute a malicious intent? You don't know, because you don't know if he's going to use it or not. Well, there might be different views, alright. If it's just nosy, then to the data subject is already an infringement of his right. Others might say that, well, I'll be very worried because if I just take a look, and then you would take me to the court. So how do we strike a balance between the two, and what are the criteria for prosecution? So can someone else, can someone help us? Or DFJ, can you help? And when we move on to the clause-by-clause examination, definitely we will be discussing this. Alright, there is one final point that we haven't discussed, so I think we have to move on. Yes, you will have to think about this, because you've been emphasizing that, well, just being nosy is not an acceptable defense. But then under the current law, what if he gains access to all patient records in Hong Kong? All right, you will only be punishing him if he is using it for some malicious intent. So where do we strike a balance between these two? Just being nosy and doing it for a malicious intent? Well, we will be discussing this again when we do the clause-by-clause examination. We'll go back and take a further look. Yes, I understand what members were saying. All right, if it's somebody trying to do this out of malice, then if he's just misbehaving himself, then should it be punishable? So is it an offense? So that's something that we will have to ponder. Yes, it's like what the Commissioner was suggesting. It's the safe deposit box. If we were to amend the existing provision so that we can afford better protection to the patients, I think that might be better. So we will then be able to tell whether or not it's excessive or have we overdone it. So I think we will have to strike a balance between not punishing at all and punishing excessively. All right. If the Commissioner can come up with some specific recommendations, please let us know before the next meeting. Can I add one word, Chairman? Well, I was suggesting that we can adopt a middle-of-the-road approach, because in overseas jurisdictions, they can also impose a penalty. Well, it can just be a monetary penalty. We are not saying that people should go to jail for this. Well, for example, for some traffic offences, it's also an offense. We are not saying that well, whenever you commit an offense, you should go to jail. But then, if we are able to impose a fine, we would also it would also serve as a deterrent. So even if you jump the red light, it's also an offense. But then, if there is no punishment at all, then there would be no deterrent effect. And if there is no deterrent effect, then is it okay? So when it comes to offense, it doesn't necessarily mean that you will have to go to jail for that. We can always impose a light sentence and a punishment that can achieve a deterrent effect without being too harsh. Yes, I think there needs to be some punishment, or else we would be encouraging people to be nosy. And for people who are able to hack a system, then he might say that I can go to your account or go to your website to take a look. And if there is no punishment at all, that would be an incentive for them to do so. So if you hack someone else's computer system, in itself is an offense, right? Yes, there are many comparables. All right, if you just pass by and take a look, or if you use your mobile phone to take a picture, or if you take the initiative to hack into the system, that would already show your intent. So by imposing some punishment, some form of punishment, or by resorting this to a civil claim, I think that would also achieve a deterrent effect. I think the difficulty here is that we have too few members here, and I would suspect that some medical sector representatives might have different views, and yet they are not here. So I think we will try to cover these today, and then in due course, when we do the clause by clause, we can bring that up again, because it's not possible for us to ask the Commissioner to come back every time, but then at least we can invite those members to consider these points. All right, let's move on to the next point, because we have to watch our time. Who would do it first? Chairman, just now we were talking about having access to the information, but then what about retrieval of the information? All right, if it's just access to the information, it's just accessing the information. But then what if he uses it after accessing the information? Then will members have a different view on this? Well, on this point, Chairman, I gave an example just now. Well, when it comes to use of the information, it's often linked with selling for direct marketing and so on. But then we also have internet bullying. So whether or not having access would cause damage is debatable. All right, if internet bullying is also incorporated or included here, would it be okay? Well, it might be difficult to define it because we haven't got similar legislation elsewhere. So can you consider this suggestion by Ms. Quad? Are there other possible offences? Well, our view on this earlier on is about misuse of information is too broad. So what's meant by misuse of the information? And it's very difficult to enforce and difficult to prosecute. A more precise act, like what Ms. Quad just said, alright, if it's bullying, then it would be easier to define. Then we would be better able to describe it in specific terms. But then if all misuses would be subject to a fine of $5,000, then it's simply not enforceable. Okay, when we move on to clause by clause, we'll be able to revisit this. Yes, as Ms. Quad just said, if you can come up with more specific examples, then it would be easier. But then for bullying, I think it's not easy to define. It's very imprecise because it can catch everything. And it can also be very broadly defined and interpreted because we haven't got that in place yet. It's not like arson, murder, and so on. So it's difficult to define what's meant by bullying. I think it's okay to discuss it now, but then we cannot go back and think about it. So can we come up with more specific definition? Alright, if it's misuse of the information, well, it might be too vague, but then you may not be able to come up with an exhaustive list. I think it's better to be more precise, and the Commissioner might also be able to come up with a definition of misuse of a computer. Because the administration thinks that the word misuse is too broad and vague. So what does the Commissioner think? Well, when we well, I might not be present when you do the clause by clause, so let me reiterate our stance. So long as you are not doing this for the purpose of a system, or for so I think the electoral legislation is an example. When you collect information about the voters, and if it's not used for the purpose of an election, then it's already against the law. It's already an offense. I think you can use that as an example. I would be prepared to accept that description. For example, if you include internet bullying, then you will have to be very specific about what's meant by internet bullying, because for the EHR system, the purpose of it is to treat patients. Any other use would be misuse, in my view. So, administration, would that be okay? Well, under the law, we have already set out that for information stored in the EHR, it can only be used for three purposes. Number one, for medical purposes. Second, for research and statistics. And third is more broad. So anything that is allowed for under the law, for example, if it's used for criminal investigation by the police, then these three purposes would be allowed under the current bill. And what comes to our mind immediately? Anything other than these three purposes would be misused, and you will have to punish that person to a certain extent. I'll have to go back and think about it. Would it catch very inappropriate use? And yet it's a somewhat neutral act. Would that be caught as well? So you may as well relax the electoral legislation so that we can make use of the information for other purposes, because the intention is the same. It's about whether or not it's too strict there. Well, I'm not an election expert, but then I think the voter register is somewhat different from what we are referring to here, because everybody can have access to that voter register. Yet here, we are only talking about healthcare institutions and also employees of those institutions. Only they will have access to the information, so it's already very narrowly defined. That's why we have this offense for unauthorized access to the information. But then we'll go back to think about it, whether or not we can come up with a better definition that can cover this. If it's and anything other than the 3 uses will be treated as misuse. So he'll go back and think if anything is missing. So will there be any use that is neutral but then is also outside the 3 purposes that I just set out? Well, you have not included that in the bill and it's already prohibited. But then you've chosen to turn a blind eye to that. Alright, you have to deter those from being committed, because you do not permit any use other than the 3 uses that you've set out. Alright, if you've come up with the 7th, 8th or 9th offenses that are punishable, then we will be prepared to consider it. But then in terms of the drafting, would we be hitting the wrong target? We have to be careful about that. Alright, we'll go back and think about it. Alright, we'll think about the both simultaneously. Alright, let's now take a look at point 6. Commissioner, can you help us? So can you share with us your view? Well, we accept the Commissioner's view, so I think we can finish in a few minutes. Really? Who go first? Who would go first? Commissioner? Thank you, Chairman. What we are concerned about is the way it is drafted now will exempt the future Commissioner who does not have to carry out a data check or audit. And if he has to do a good job, and after all, the purpose of the bill is that the reason for creating this post of Commissioner is to ensure that the database would be properly protected. And given the fact that the role of the Commissioner for Electronic Health Record has been spelled out so clearly, and if you are not giving him specific powers to do that, then that would render his work very difficult, because that would also affect the enforcement of this law. Because if we see that he is not doing his job, then we can also issue a direction or a directive for the institution concerned to conduct a data check to remedy the situation. In the past, we have done so by issuing such directives, and if the bill is enacted as it is without any amendment, then in terms of enforcement, we would not be able to impose it on the future Commissioner for HRC, and that would weaken the ability of us protecting the system, and that would be problematic.
But I've heard from the administration, they already have a different view on this. So I would like to collect more details on different views. 57(2), maybe I can explain the background. Legal liability on public offices. 57(2), the intent is some people, for frivolous reasons, complain that the authority for the EHR system has not checked certain information to ascertain their accuracy. If anyone uses that as the ground for complaint, we feel that we need to protect the public officer, because the office is just the operator of the system. It will reach the platform and the different portals, but there are separate systems inside clinics or hospitals. Some of that information may be shared with us. Some may be their own operational data, and we should not and do not have the right to check such information on other people's computers. So that is not part of our system. Even if we do check their computer systems, it does not necessarily lead to accuracy. Because on a certain day, this person went to this doctor, took certain meds, or had this operation. The person who treated this patient or the institution that took him in can tell you whether the record is accurate. Any system administrator cannot tell if 3 years ago he indeed took 5 types of medicine at your hospital. So we put this down to make sure the public officers will not have to show their legal liability. But we understand that the Privacy Commission has some concerns. For example, I demand that you check the system. With this provision, I can rely on this provision and not follow that order. We understand the Commissioner's concern. So after considering this concern, we can remove it. 57 bracket 2. 57 bracket 2. We can just remove it. They can retain the power to ask the office to ascertain the accuracy of the data. I would like to clarify. We're not talking about whether this wording or the opinion written down by a doctor should not be examined to see whether it is accurate or not. But in the process, if you see maladministration leading to the entire system or the data bank will suffer from the lack of accuracy of the data. That is what we're talking about. So the officer will have to take up this responsibility, and we don't have any comments on to what extent his responsibilities should go. But we don't want any person not having a sense of danger or risk. If there is maladministration, action should be taken to address it. So we are happy to accept this proposal from the administration to remove this exemption. That means they can do it, they can choose not to do it. They can do it, we can do it. But we can no longer rely on this provision to evade complaints, perhaps not grounded complaints. Ms. Kwok? I think the administration is being very responsive, and that is a good thing. The Commissioner is not obliged to inspect or commit to inspect an e-medical record system. That causes some questions in my mind. You cannot ascertain if any system is accurate, but if the system, whether it is operating well, or do you ensure that medical institutions connected with the system, whether they are using the system in a correct manner? I think the Commissioner should hold such powers, and he is responsible. So removing it, I agree with removing this provision. Anything you would like to add? No? Nothing to add? In that case, I can announce that meeting adjourned. We'll see when we can have a next meeting. We'll see how we can pick up from other points for the next meeting. Thank you very much. Thank you, Commissioner. It's so much trouble for you.